Good morning. Today I am going to discuss the subjects already discussed, but for the purpose of recollections and for full preparation of examination. First, the word arrest, remand, police custody, pre-trial remand under section 309 CRPC, and thereafter by conviction. All are process of curtailment of fundamental right to move from one place to other place. And also Article 21, right to live, dignity. We are confined in a prison without proper food, proper civic facilities, proper medical care, then automatically Article 21 applies. So, for curtailment of those fundamental rights, there should be a due process of law, that is Code of Criminal Procedure Code. So we have already seen how arrests are made. Then the question arises, once arrest is effected, then what all are the uh, process of bail applications? See, that first section is section 59. 59 commences the right of bail. That 59, what 59 says, no person who has been arrested by police officer shall be discharged except on his own bond or on bail or under the special order of magistrate. So this is section 59 is the first bail application. I have already told multi number of times that bail is similar a word to bailment in civil procedure code, in civil law. So this is not that if you are executing a bond or if you are released on bail by two sureties, then it shall be continuation of detention. But instead of prison, you are being placed under the custody of third party who has to take care of you. Then question arises, what will be the next bail application? You can see at the time of pronouncing sentence for certain offences under section 106 CRPC, when a court of sessions or court of magistrate of first class convicts a person any of the offences specified under subsection 2 or of abating any such offence, his opinion it is necessary to take security from such person for keeping peace, the court may at the time of passing sentence also order him to execute a bond. So again there shall be an execution of bond. Wow. Then question arises, 167 class 2. 167 class 2 says, if the period of remand limited to 60 days if the offences are punishable within 10 years, it limited to 90 days if the offences are more than 10 years. Then the investigation process should be completed. If not completed and final report filed, then the accused is entitled for bail under section 167 class 2. So that is most important. Then you see, what about 436? 436, if it is offence is bailable, automatically you are entitled for bail. Then you are entitled for bail. Then 437, 436A says, if a under trial prisoner is being kept for more than half of the sentence for which he is liable to be punished, he shall be enlarged on bail. That is 436A. And recently, for NDPS's case, when there is a bar for consideration about the prima facie allegations, the Supreme Court has said that is If the 436A is applicable, that bar is not applicable. Then 437 deals with the offences of non-bailable. But again, you can see 437 subclass 2, where you can claim bail instantaneously if it appears to such court or officer at any stage of the investigation, inquiry or trial as may be, that there are no reasonable ground for believing that the accused has committed non-bailable offence, but that there are sufficient grounds for further inquiry, the accused shall be enlarged on bail. This is what they say. This is another offence. Then 437 subclass 6. If any in case triable by magistrate, trial of person accused of any non-bail is not concluded within this period of 60 days from the first date fixed for the evidence, he is custody, he shall be released on bail. This is what they say. Then question arises, anticipated bail 438, then appeal, pending appeal, bail 389 CRPC, then revision 397 CRPC, then 424 CRPC says, if any person is levied fine and he can seek time for payment of fine by filing bail application for 424 CRPC for suspension of sentence. Apart from that, there are so many other provisions for grant of bail. Therefore, kindly go through section 59. When you can file section 59 CRPC, if the accused is arrested and produced before the magistrate and there is absolutely no prima facie material, then you can file under section 59 CRPC along with Arnesh Kumar judgment, Supreme Court judgment, and seek discharge of that. Then 436, you can file bail application. Then 437 directly, or 437 subclass 2, if you are having material to argue before the court that the accused arrested was not committed any offence punishable for under category of non-bailable offence. Then 437 6, if the trial has not been completed, then the magistrate can release him on bail. These things are most important. Then question of suspension of sentence. If the accused is convicted, even at the initial day of conviction itself, you can file an application for suspension of sentence stating that he likely to prefer appeal. There are arguable points for prefer to succeed in the appeal. Then that should be limited if the sentences are limited 3 years within the magistrate court and sessions court 3 years are there. Then you must understand that after filing appeal you can get a bail pending appeal. If it is revision, you can seek suspension of sentence even if you are detained under any order. Judgment is different. Order means it is 107, 190. These sort of orders are being passed. And all these things you should carefully go through. Consolidately, you must prepare your mind to argue the case from the very basic point of analysis of jurisprudence. What is the human liberty? When your human rights, liberties are considered most vital to be extended and protected by the sovereignty. Sovereignty means the government, or if they are king, it is his duty. If the dictator or sultanate is there, all are subjected to. And because we are member of United Nations organization, which declared a declaration of human rights, so we are bound to follow that. Otherwise, we will be subject to trial by the United Nations organizations, human rights wings. These all are a vital part when you substantially argue, consolidately, or instead of answering the question. Objective type, no problem about that. What about theoretical type of argument? When the question is put to you, you have to answer. These all are the things. Yesterday, yes, I hope we will continue tomorrow. Good morning.